Welcome, loyal viewers, to Beyond Midnight. If you haven't already, take a moment to subscribe and join our community as we delve into the shadows of history, exploring the often chilling realities that shaped our world. Tonight, we journey back to a time when life hung by a thread, when the line between innocence and guilt was razor thin, and when a single misstep could mean the gallows. We are stepping into the brutal, complex, and often terrifying world of medieval law. This is one mistake and you'd hang. Medieval law. Imagine, if you will, a world utterly alien to our own. A world without police forces as we know them, without forensic science, without the intricate web of codified statutes that define our modern justice systems. This was the Middle Ages, a vast epoch spanning roughly 1,000 years from the fall of Rome to the dawn of the Renaissance. It was a time of deep faith, pervasive superstition, constant conflict, and profound social stratification. In such a world where order was fragile and chaos ever present, how was justice administered? How did society attempt to impose a semblance of peace, to punish wrongdoing, and to protect its members? The answer is a mosaic of custom, divine will, feudal power, and the ever-present threat of ultimate, irreversible punishment. Life in the medieval era was, for the vast majority, short, brutal, and precarious. The average peasant toiling in the fields lived under the shadow of famine, disease, and the arbitrary power of their lord. There was no social safety net, no widespread education, and certainly no concept of individual rights in the way we understand them today. Your identity was largely defined by your birth, your village, and your relationship to your immediate lord or the church. In this intensely local and hierarchical society, the law was not an abstract concept. It was a living, breathing, often terrifying force that touched every aspect of daily existence. It was not something written in a grand book in a distant capital, but rather an amalgam of ancient customs, religious dogma, and the personal will of those in power. The very foundation of medieval law was custom. For centuries, before kings began to assert their widespread authority, before the church codified its vast body of canon law, and before towns developed their own unique charters, justice was dispensed based on what had always been done. This unwritten law, passed down through generations, was seen as immutable, almost divinely ordained. It was the way things were, the way things had always been. If a dispute arose over land boundaries or a theft occurred, the community would look to the elders, to the collective memory, to determine the appropriate course of action. This reliance on custom meant that law was inherently local and varied wildly from one village to the next, from one feudal domain to another. What was acceptable in one shire might be a grave offense just a few miles away. This patchwork quilt of legal traditions made the landscape of medieval justice incredibly complex and, for the uninitiated, incredibly dangerous. Beyond custom, the two great pillars of medieval authority, the church and the monarchy, gradually began to assert their own legal jurisdictions, creating a multi-layered system that often overlapped, sometimes conflicted, and always held immense power over the lives of ordinary people. The church, with its spiritual authority and vast landholdings, developed an elaborate system of canon law, governing matters of faith, morality, marriage, inheritance, and the conduct of the clergy. The king, as the ultimate feudal overlord, slowly but steadily expanded his royal justice, particularly for serious crimes that threatened the peace of the realm, such as murder, treason, and grand larceny. And then there were the local lords, the barons, knights, and abbots, who held their own courts, administering justice over their tenants for a myriad of petty offenses and civil disputes. Finally, the burgeoning towns and boroughs, granted special charters by the king, developed their own unique legal systems, often focused on commercial disputes and maintaining urban order. This fragmentation of justice meant that where you committed a crime, and even who you were, could drastically alter the legal process and the potential outcome. A peasant stealing a loaf of bread from his lord's granary would face the manorial court. A priest accused of heresy would face an ecclesiastical court. A knight committing treason against the king would face royal justice, and a merchant cheating another in the marketplace of a chartered town would face the borough court. Each had its own procedures, its own forms of evidence, and its own range of punishments. This labyrinthine system was not designed for clarity or consistency, but rather to uphold the existing social order and the power structures that defined it. Let us begin our deep dive into these distinct realms of medieval justice, starting with the most common and immediate form of law for the vast majority of the population, the manorial court. For the peasant tied to the land, living out their lives within the confines of a lord's manor, the manorial court was the face of justice. These courts, often held in the great hall of the manor house, or sometimes simply outdoors under a prominent tree, were presided over by the lord himself, or more commonly, by his steward. They met regularly, perhaps every few weeks, and were concerned with the day-to-day running of the manor, the enforcement of its customs, and the resolution of disputes among the tenants. Imagine the scene, a small, crowded hall filled with the murmuring voices of villagers. The air is thick with the smell of damp earth and unwashed bodies. Before the steward sits a table, perhaps with a few rudimentary documents, records of previous cases, lists of fines. On one side stands a peasant, perhaps named Thomas, accused by his neighbor Agnes of allowing his pigs to root up her garden patch. On the other side, Agnes, her face flushed with indignation, recounts the damage. This was the bread and butter of the manorial court. Petty trespass, minor assaults, disputes over inheritance of small plots of land, failure to perform labor services owed to the lord, breaches of manorial custom, and disputes over stray animals. The manorial court was not about abstract legal principles. It was about maintaining order and ensuring the smooth functioning of the agricultural economy. Its primary goal was often reconciliation and compensation rather than severe punishment. Fines were the most common outcome. Thomas, for his pigs, might be fined a few pence, or perhaps a measure of grain, to compensate Agnes and to serve as a deterrent. These fines, of course, went directly into the lord's coffers, providing a convenient source of income. For more serious infractions, such as theft of tools or repeated insubordination, the court might order a public shaming, like placement in the stocks or pillory, or even, in rare and extreme cases, expulsion from the manor, a sentence akin to a death sentence, as it meant homelessness and starvation in a world with no safety nets. The process in a manorial court was remarkably informal compared to modern standards. There were no lawyers, no complex rules of evidence. Accusations were made, and the accused was expected to respond. The court relied heavily on the testimony of neighbors, the collective knowledge of the community, and often the simple word of the lord or his steward. Sometimes, a jury of local men, often 12 of them, would be impaneled from the community to decide on the facts of a case. These were not juries in the modern sense, tasked with sifting through evidence and applying legal statutes, but rather men who were already familiar with the parties involved and the local customs, whose role was more akin to witnesses or oath helpers, affirming what they knew or believed to be true. Their verdict was often a reflection of community consensus, or simply the will of the lord. The manorial court records, where they survive, paint a vivid picture of medieval village life. They show a society deeply concerned with reputation, with communal harmony, and with the strict adherence to established norms. They reveal the petty squabbles, the occasional acts of violence, and the constant struggle for survival that define the lives of ordinary people. While these courts rarely dealt with crimes that would lead to a hanging, they were the immediate and ever-present hand of justice, shaping behavior and enforcing the hierarchy of the feudal system. They taught the peasant that their lives were governed by rules, and that infractions, however minor, would not go unnoticed or unpunished. Moving up the ladder of medieval justice, we encounter the formidable power of the ecclesiastical courts or church courts. The Church, during the Middle Ages, was not merely a spiritual institution. It was a colossal temporal power, wielding immense influence over all aspects of life, from politics to personal morality. Its legal jurisdiction was vast, encompassing not only matters of faith and doctrine, but also a surprising array of secular issues. Canon law, the body of law developed by the Church, was arguably the most sophisticated and comprehensive legal system of the Middle Ages, drawing inspiration from Roman law and theological principles. It governed all clergy, from the lowliest parish priest to the Pope himself, regardless of the crime, but its reach extended far beyond the clergy. It had jurisdiction over all matters relating to marriage, divorce, legitimacy of children, wills, oaths, defamation and usury, lending money at interest, considered a sin. More importantly, it had jurisdiction over sins that were also crimes, such as heresy, blasphemy, witchcraft, though this became more prominent later in the period, and sexual offenses like adultery and fornication. Imagine a priest accused of theft, or a local lord accused of bigamy, or a woman accused of practicing witchcraft. These cases would not go to the king's court or the manorial court. They would be heard in the bishop's court or an archdeacon's court, or even, for very serious matters, by a papal delegate. These courts were often more formal than manorial courts, employing written procedures and sometimes even having trained legal professionals, though not in the modern sense of barristers. Evidence could include witness testimony, documents, and confessions. The punishments meted out by ecclesiastical courts were distinct from those of secular courts. The Church, in theory, could not shed blood. Therefore, capital punishment, mutilation, or imprisonment were generally not on their menu of sanctions. Instead, punishments focused on spiritual penance and public humiliation. Offenders might be excommunicated, cut off from the sacraments, a terrifying prospect in a deeply religious age, ordered to perform public penance, such as standing barefoot in church or wearing a white sheet, fined often for the benefit of the poor or the church, or ordered to go on a pilgrimage. For serious heresy, the ultimate punishment was to be handed over to the secular arm, meaning the church would declare the individual a heretic and then turn them over to the state for execution, often by burning, which was seen as a purification of the soul through fire, rather than a shedding of blood. Two critical concepts in ecclesiastical law stand out for their profound impact on medieval justice: benefit of clergy and sanctuary. Benefit of clergy was a privilege that allowed members of the clergy, and later, anyone who could read, to be tried in an ecclesiastical court rather than a secular one for most crimes. The idea was that those who served God should be judged by God's law, not by the rough justice of the temporal world. To prove one's clerical status, one simply had to read a passage from the Bible, typically Psalm 51, known as the neck verse because it could save one from the gallows. If you could read it, you were considered literate enough to be a cleric, and thus eligible for the benefit. This often meant a much lighter sentence, as church courts avoided capital punishment. This privilege, however, created a significant loophole in the justice system, allowing educated criminals to escape the harshest penalties of royal law. It was a source of constant tension between church and crown, as kings resented the church's interference with their jurisdiction over serious crimes. Sanctuary, on the other hand, was the right of an accused person to take refuge in a church or other holy place, thereby escaping immediate arrest by secular authorities. The concept was rooted in the idea that a holy place offered divine protection. If a person fled to a church and claimed sanctuary, they were safe from arrest for a certain period, usually 40 days. During this time, the secular authorities could not enter the church to apprehend them. The individual was then faced with a choice: confess their crime and submit to the church's judgment, which again would avoid capital punishment, or abjure the realm, meaning they would confess their crime, swear an oath to leave England by the nearest port and never return. If they chose to abjure, they would walk out of the church, often barefoot and carrying a cross under the protection of the authorities to the port and then banished. If they failed to leave or returned without permission, they could be executed without further trial. Sanctuary provided a temporary reprieve, a chance to negotiate or escape, but it was not a path to absolute freedom. It was a powerful demonstration of the Church's authority to intervene in secular matters, and like benefit of clergy, it was a constant source of friction with royal power. While manorial courts dealt with the everyday squabbles and ecclesiastical courts with matters of the soul and clergy, the truly terrifying power of medieval law lay with the royal courts. It was here that the most serious crimes were tried, crimes that were considered offenses against the king's peace and dignity, and it was here that the ultimate penalty, death by hanging, was most frequently applied. The king's justice was not always paramount throughout the early Middle Ages. In the chaotic aftermath of the Roman Empire's collapse, local lords held immense power, and royal authority was often limited. However, over centuries, particularly in England after the Norman conquest of 1066, kings began to systematically expand their jurisdiction, gradually eroding the power of local feudal lords and the church. This was a slow, arduous process, driven by the desire for centralized control, increased royal revenue from fines and forfeitures, and the perceived need for a more uniform system of justice across the realm. The primary instruments of royal justice were the Eyre and later, the Assizes. The Eyre was a system of itinerant royal justices who traveled throughout the country, holding courts in each county, investigating all manner of crimes, administering justice, and inquiring into royal revenues. These were momentous occasions, often occurring only once every few years, and they were dreaded by local communities. The justices would hear not only serious criminal cases, but also investigate local administration, collect taxes, and punish corrupt officials. When the justices of Eyre came to town, the entire community was expected to participate, presenting indictments, serving on juries, and answering for any breaches of the king's peace. By the 13th century, the Eyre system began to be supplemented and eventually replaced by the more regular assizes. Royal judges, appointed by the king, would travel on circuits throughout the country several times a year, holding court in major towns. These judges heard the most serious criminal cases, known as pleas of the crown or felonies. Felonies were crimes so grave that they incurred the forfeiture of the offender's land and goods to the crown, in addition to the possibility of capital punishment. These included murder, rape, arson, robbery, and grand larceny, theft of goods above a certain value, typically 12 pence, which was a significant sum for a peasant. Treason, an offense against the king himself, was considered the most heinous crime of all, carrying with it the most brutal forms of execution. The royal courts were the arena for what was known as high justice, the power to inflict capital punishment. Unlike the manorial courts, which aimed for reconciliation, or the ecclesiastical courts, which sought spiritual penance, the royal courts were primarily concerned with punishment and deterrence. The spectacle of justice was a crucial element. Public trials, public punishments, and public executions were designed to instill fear, to demonstrate the king's power, and to reinforce the social order. The procedures in royal courts, while still far from modern standards, were more formalized than those in manorial courts. Cases would often begin with an accusation, either by a private individual or, increasingly, by a presenting jury or jury of presentment, the precursor to the grand jury. This jury, composed of local men, would present to the royal judge a list of suspected criminals and their alleged offenses, based on common knowledge and local rumor. Once accused, the defendant faced a daunting challenge. There was no presumption of innocence. The burden of proof was effectively on the accused to demonstrate their innocence. There were no lawyers to defend them. They had to speak for themselves. The methods of proof employed in royal courts evolved significantly throughout the Middle Ages. In the early part of the period, particularly before the 13th century, Justice often relied on what we would consider irrational or superstitious methods, rooted in the belief that God would reveal the truth. These were the infamous ordeals. The ordeal was a judicial process by which the accused underwent a physical test, the outcome of which was believed to be a direct manifestation of God's judgment. If God intervened to protect the accused, they were innocent. If not, they were guilty. There were several common forms of ordeal. Ordeal by hot iron. The accused would carry a red-hot iron bar for a certain distance, typically 9 feet. Their hand would then be bandaged, and after 3 days it would be inspected. If the wound was clean and healing, God had intervened and the accused was innocent. If it was festering or infected, they were guilty. The interpretation of healing was, of course, subjective and often left to the discretion of the priest overseeing the ordeal, who might be influenced by local opinion or the severity of the accusation. Ordeal by hot water. The accused would plunge their arm into a cauldron of boiling water to retrieve a stone. Like the hot iron ordeal, the wound would be inspected after 3 days. A clean wound meant innocence, an infected one meant guilt. Ordeal by cold water. This was primarily used for accusations of witchcraft or heresy, particularly later in the period. The accused, often bound, would be thrown into a body of water. If they sank, they were considered innocent, as the pure water accepted them, and were then pulled out. If they floated, they were considered guilty, as the water rejected them, implying they were unnatural or in league with the devil, and then faced further punishment, often execution. This ordeal was particularly insidious because it was a no-win situation. If you sank, you might drown. If you floated, you were guilty. Ordeal by morsel, or the coarsened. This was typically reserved for the clergy. The accused would eat a piece of consecrated bread or cheese. If they choked or showed signs of distress, they were deemed guilty. The idea was that an innocent person would be able to swallow it without difficulty. The ordeals were a testament to the deeply religious worldview of the Middle Ages. They were not seen as arbitrary tests, but as direct appeals to divine judgment, a way for God to reveal what human reason could not ascertain. However, their use began to decline significantly after 1215, when the Fourth Lateran Council, a major church council, prohibited clergy from participating in or blessing the ordeals. Without the church's sanction, the ordeals lost their legitimacy and rapidly fell out of favor, leading to a profound shift in legal practice. With the decline of ordeals, courts increasingly turned to other methods of proof, primarily the jury system, which began to take on a more recognizable form. The trial jury, as opposed to the presenting jury, emerged as the primary means of determining guilt or innocence. This jury, typically composed of 12 men from the local community, was initially expected to already know the facts of the case, acting as both witnesses and adjudicators. Over time, their role evolved from knowing the facts beforehand to hearing evidence presented in court and making a judgment based on that evidence. Witnesses, though not examined with the rigor of modern cross-examination, played an increasingly important role. People would testify to what they had seen or heard, or to the character of the accused. The concept of oath helpers, or compurgators, also remained significant, especially in civil disputes or less serious criminal cases. In compurgation, the accused would swear an oath of innocence, and then a certain number of respectable men, often 12, from the community would swear that they believed the accused's oath to be true. This was not testimony to the facts of the case, but rather an affirmation of the accused's good character and trustworthiness. If enough oath helpers could be found, the accused was acquitted. This system heavily favored those with good standing in the community and a network of supportive neighbors. Another method of proof, particularly for disputes between nobles, was trial by battle or judicial combat. This was based on the belief that God would grant victory to the righteous party. The two parties in a dispute, or their champions, would fight a duel. The victor was considered to have God's favor and thus to be in the right. This was a brutal and often fatal method of resolving disputes, and while it eventually faded from common use, it remained a legal option in England for centuries, though rarely invoked for criminal matters by the late Middle Ages. Finally, there was the confession. A confession, especially one freely given, was considered the most powerful form of evidence. However, the line between a free confession and one extracted under duress was often blurred. Torture, while not formally part of English common law, it was more prevalent in continental Europe, particularly under Roman law influence and in inquisitorial systems, was certainly used in practice, especially for serious crimes like treason or heresy, or to extract information from suspects. The rack, the strappado, and various forms of pressing or crushing were employed to break a prisoner's will and force a confession, which would then be presented as proof of guilt. The use of torture highlights the brutal reality that medieval justice was often less concerned with abstract notions of fairness and more with obtaining a swift resolution, particularly when the accused was already widely suspected. Once guilt was established, whether by ordeal, jury, compurgation, or confession, the grim business of punishment began. Medieval punishments were not designed for rehabilitation. The concept barely existed. They were designed for deterrence, for retribution, and for public spectacle. They were often swift, brutal, and deeply symbolic, reflecting the nature of the crime and the social standing of the offender. Fines were, as mentioned, common for minor offenses, particularly in manorial courts. But for more serious crimes, the consequences were far graver. Humiliation was a popular form of punishment, designed to shame the offender and serve as a public warning. The stocks and the pillory were ubiquitous fixtures in medieval towns and villages. The stocks confined the legs and sometimes the hands of the offender, leaving them exposed to the elements and the jeers, insults, and even rotten food thrown by passers-by. The pillory, often a wooden frame with holes for the head and hands, similarly exposed the offender to public ridicule. These punishments were often used for petty theft, public drunkenness, brawling, or selling adulterated goods. The shame and ostracism could be long-lasting. Mutilation was another common and terrifying form of punishment, particularly for repeated offenses or specific crimes. It was often seen as a way to mark the criminal for life, a permanent scarlet letter. A thief might have a hand cut off. A perjurer might have their tongue cut out. A persistent poacher might lose an ear. Branding, often on the face or hand, served a similar purpose, marking the individual as a criminal and making it difficult for them to escape their past. These punishments were gruesome, painful, and left the victim permanently disfigured, serving as a stark reminder to the community of the consequences of crime. The idea was often an eye for an eye, a direct physical punishment related to the offense. Imprisonment as a form of punishment was relatively rare in the Middle Ages. Jails and dungeons existed, but they were primarily used as holding cells for suspects awaiting trial or execution, or for debtors who couldn't pay their fines. Long-term incarceration as a punitive measure, distinct from the death penalty or exile, was not common until much later in history. The cost of feeding and housing prisoners was prohibitive, and the prevailing philosophy was that punishment should be swift and visible. The ultimate punishment, the one that truly embodies the title of this documentary, was execution. Death was the final arbiter of justice for a wide range of felonies, and especially for treason. The methods of execution were varied, reflecting the severity of the crime and the status of the condemned. Hanging was the most common form of capital punishment for common criminals convicted of felonies like murder, robbery, or grand larceny. The gallows were a common sight on the outskirts of towns, a grim reminder of royal justice. Executions were public spectacles, drawing large crowds. They were meant to be a deterrent, a chilling performance of the king's power over life and death. The condemned would often be paraded through the streets, sometimes with a rope around their neck, to the place of execution. The process itself was crude. A long drop was not guaranteed, leading to slow strangulation rather than a broken neck, prolonging the agony. For crimes against the king, particularly treason, the punishments were far more gruesome and elaborate, designed to inflict maximum suffering and to serve as a terrifying warning. The most infamous was hanging, drawing, and quartering, reserved for men convicted of high treason. The condemned would first be drawn on a hurdle, a wooden frame, to the place of execution, ensuring they were still alive for the subsequent horrors. They would then be hanged, but cut down while still alive. Their entrails would be removed and burned before their eyes, drawing. Finally, their body would be dismembered into 4 parts, quartering, and these parts, along with the head, would often be displayed in prominent public places, such as on spikes on London Bridge, as a stark warning to anyone contemplating rebellion against the crown. This was not just punishment, it was a ritualized act of public terror, designed to utterly annihilate the traitor's body and reputation. For women convicted of treason, the punishment was often burning at the stake. This was seen as a more chaste form of execution than hanging, drawing, and quartering, as it avoided public dismemberment. However, it was no less horrific. The condemned would be tied to a stake surrounded by faggots of wood and then burned alive. This method was also used for heresy, particularly in the later Middle Ages, as fire was believed to cleanse the soul. Beyond these common methods, other forms of execution existed, though less frequently. Beheading, often with an axe or sword, was typically reserved for nobles and those of higher social standing, considered a more honorable and less ignominious death than hanging. Drowning was sometimes used, particularly for women, in some local jurisdictions. The concept of justice in the Middle Ages was inextricably linked to the idea of divine order and social hierarchy. Law was not seen as an instrument of individual rights or rehabilitation, but as a tool to maintain the king's peace, enforce religious doctrine, and uphold the feudal system. The severity of punishments, the public nature of executions, and the reliance on methods like ordeals and compurgation all reflect a society deeply rooted in faith, fear, and a stark understanding of power. The lack of legal representation, the absence of a presumption of innocence, and the often arbitrary nature of evidence meant that navigating the medieval legal system was incredibly perilous. A simple accusation, fueled by rumor or personal animosity, could set in motion a chain of events that was nearly impossible to stop. Without the means to hire oath helpers, without a good reputation in the community, without powerful friends or connections, an ordinary person accused of a serious crime stood very little chance. Their fate rested on the whims of a lord, the interpretation of a priest, or the verdict of a jury of neighbors who might already have made up their minds. Consider the daily life of a peasant. Their existence was a constant struggle against the elements, against hunger, and against the demands of their lord. They lived in small, often isolated communities where everyone knew everyone else's business. Reputation was everything. A good name could mean the difference between life and death if ever accused of a crime. If you were known as a hard worker, honest, and pious, your neighbors might be willing to stand as oath helpers for you, or a jury might be more inclined to believe your word. But if you were known as a troublemaker, a shirker, or someone who didn't attend church, your standing in the community could seal your fate. The role of the community in medieval justice cannot be overstated. It was not just the lord or the king who administered justice. It was the entire village, the hundred, the shire. The presenting jury, for example, was composed of local men who were expected to know the criminals in their midst. When a crime occurred, it was often the community that first responded, raising the hue and cry to pursue the offender. If a thief was caught in the act, they might face immediate, summary justice from the enraged villagers. This communal aspect meant that justice was often deeply intertwined with local gossip, feuds, and long-standing grudges. The concept of felonious intent, or mens rea, guilty mind, was present in medieval law, but it was often difficult to prove. While a distinction was made between accidental death and murder, the methods of proof were crude. Confessions, as we've noted, were highly prized, even if coerced. The idea that a person could be genuinely innocent, but simply unable to prove it, was a terrifying reality. The slow evolution of the jury system, particularly in England, was a significant step towards a more rational and evidence-based form of justice. From a body of men who knew the facts, the jury gradually transformed into a body that heard the facts presented by others. This shift was gradual and incomplete throughout the Middle Ages, but it laid the groundwork for the modern jury trial. The Magna Carta, signed in 1215, while primarily a document about the rights of barons, contained clauses that eventually contributed to the development of due process, such as the famous Article 39, which stated that no free man should be imprisoned or dispossessed, except by the lawful judgment of his peers or by the law of the land. This was a crucial, albeit slow, step towards limiting arbitrary royal power and establishing a principle of legal process. However, even with the emergence of juries, the medieval legal system remained fundamentally different from our own. There was no concept of innocent until proven guilty. If you were accused, you were presumed to be in need of proving your innocence. There was no right to silence, no right to legal counsel, and no appeals process in the modern sense. Once a verdict was rendered, it was generally final. The consequences were immediate and often irreversible. Let us consider a hypothetical case to truly grasp the stark reality of medieval justice for the common person. Imagine a cold, wet winter in a small village in, say, 14th century England. Our protagonist is a young peasant named Alara, barely 20 years old, who works tirelessly in the fields. Her family is poor, constantly on the brink of starvation. One particularly harsh night, her younger brother, sickly and frail, collapses from hunger. Desperate, Alara makes a terrible decision. She slips into the Lord's granary, a place where the village's grain stores are kept, and attempts to steal a small sack of wheat, just enough, she hopes, to keep her family alive through the brutal winter. She is caught. A watchman, a burly man loyal to the Lord, hears a rustle and discovers her hands still clutching the sack. The alarm is raised. Alara is dragged before the Lord's steward the very next morning. The charge, theft, specifically grand larceny, as the value of the wheat is deemed to be above the threshold of 12 pence, the value that separates petty theft from a felony. Her fate will be decided in the Manorial Court, but the steward, recognizing the severity of the crime, theft from the Lord, was a grave offense, undermining his authority and the very basis of feudalism, decides to refer the case to the royal justice, who is due to pass through the region on the next circuit of the Assizes in a few weeks. Alara is thrown into the Lord's dungeon, a cold, damp, rat-infested pit beneath the manor house, to await her trial. There is no bail, no comfort, no one to speak on her behalf. Her family, terrified, can do nothing but pray. Weeks later, the royal judge arrives. The court is convened in the market square, a makeshift platform erected for the occasion. The entire village is compelled to attend, a chilling audience to the unfolding drama. Alara, pale and emaciated from her time in the dungeon, is brought forth. The presenting jury, composed of 12 men from the village, stands before the judge. They are asked if they know of any crimes committed in their community. One of them, perhaps a man who holds a grudge against Alara's family, or simply one who fears the Lord's displeasure, steps forward and formally presents the accusation against Alara for the theft of the Lord's wheat. Alara is asked how she pleads. She stammered, trying to explain her brother's hunger, her desperation, the gnawing fear of watching him fade. But her words are halting, unpracticed, and she has no one to articulate her plight effectively. The judge, a stern man with weary eyes, cuts her off. Guilty or not guilty, he demands, his voice echoing across the hushed square. In this era, a plea of not guilty was not a simple statement. It was a challenge to the court. an assertion that the accused was prepared to undergo the trial. Ilara, overwhelmed and terrified, barely whispers, "Not guilty." The trial proper begins. There are no lawyers for Ilara. She stands alone before the judge, facing her accusers. The watchman who caught her testifies, describing how he found her, the sack of wheat clearly in her possession. The steward testifies to the value of the stolen grain, confirming it was indeed a felony. The presenting jury, having already accused her, now sits as the trial jury. They are the same men, local villagers, some of whom know Ilara and her family. They are not impartial, unbiased arbiters of fact. They are men of the community, already aware of the accusation, and likely influenced by the Lord's authority and the prevailing sentiment. Ilara attempts to speak again, to plead for mercy, to explain the dire circumstances that drove her to act. But her pleas are not evidence in the way we understand it. Her character, her poverty, her desperation, these are not legal defenses that can mitigate the crime of theft from the Lord. The judge listens impassively. He asks the jurors if they have any further questions for the accusers or for Ilara. They do not. Their minds are largely made up. The jury retires briefly, perhaps to a corner of the square to deliberate. Their deliberation is likely swift. They know the facts as presented. The grain was stolen, Ilara was caught with it, and the value makes it a felony. They know the Lord demands justice. The consequences of a not guilty verdict, should they defy the implicit will of the Lord or the clear evidence, could be unpleasant for them. Within minutes, they return. The foreman, a man named John, steps forward. His voice is flat as he delivers the verdict: guilty. A collective gasp goes through the crowd, quickly stifled by the presence of the Lord's men-at-arms. Ilara's heart sinks. She knows what comes next. The judge, without hesitation, pronounces the sentence. For grand larceny, the penalty is clear and unyielding: hanging. Ilara will be taken to the gallows at dawn. Her few meager possessions, her family's hovel, everything they own will be forfeited to the Lord. There is no appeal. There is no mercy. Her single, desperate mistake has sealed her fate. This hypothetical but historically accurate scenario illustrates the brutal efficiency and unforgiving nature of medieval justice. For the vast majority of people, life was a constant struggle for survival, and the law was a tool of control, not a protector of individual rights. The line between life and death was thin, and a single act of desperation, a moment of weakness, could lead to the ultimate, irreversible punishment. But what of the enforcement of law in a world without modern police forces? In the early Middle Ages, law enforcement was largely a communal affair. The hue and cry was the primary mechanism for apprehending criminals. If a crime was discovered, the victim or any witness was expected to raise the alarm, shouting and crying out, and everyone within earshot was legally obligated to drop what they were doing and join the pursuit. Failure to join the hue and cry could result in a fine. This system relied on community solidarity and the immediate response of neighbors. If the criminal was caught, they might face summary justice on the spot or be brought before the local court. As royal power grew, more formalized roles emerged. The shire reeve or sheriff, appointed by the king, became a crucial figure in each county. The sheriff was responsible for maintaining the king's peace, apprehending criminals, collecting royal taxes, and overseeing the county courts. He was assisted by local constables, typically appointed from the community, who were responsible for maintaining order within their villages or towns. These were not professional police forces. They were ordinary citizens serving a temporary, unpaid role. Towns, with their growing populations and commercial activities, often developed their own watchmen, who patrolled the streets at night to prevent crime and maintain order. These watchmen, like the constables, were often ordinary citizens fulfilling a civic duty. Their effectiveness varied greatly, and crime in urban areas remained a significant problem. The methods of investigation were rudimentary. There was no forensic science, no fingerprinting, no DNA analysis. Investigations relied on witness testimony, confessions, and circumstantial evidence. Reputation and rumor played a huge role. If a person was known to be a vagrant, a stranger, or someone with a bad reputation, they were far more likely to be suspected and convicted than a well-respected member of the community. This often meant that the poor and marginalized were disproportionately targeted and punished. The concept of evidence was far less stringent than today. Hearsay was often accepted. The word of a nobleman or a priest carried far more weight than that of a peasant. Confessions, as mentioned, were highly valued, and the pressure to confess, whether through social coercion, fear, or actual physical duress, was immense. The medieval legal system was not designed to protect the accused. It was designed to identify and punish those deemed guilty, often with brutal efficiency, to maintain order and deter others. The influence of the Church on medieval law extended beyond its own courts. Christian morality permeated the entire legal system. Sins were often crimes, and crimes were often seen as sins against God. Concepts like perjury, blasphemy, and usury were prosecuted not just as breaches of secular law, but as affronts to divine order. The omnipresent threat of eternal damnation, combined with the very real threat of earthly punishment, created a powerful system of social control. The concept of justice itself was different. It was less about rehabilitation and more about retribution and deterrence. The public nature of punishments, the stocks, the pillory, the gallows, served as a constant, visible reminder of the consequences of breaking the law. These spectacles were intended to instill fear and reinforce the power of the authorities. For the common person, the law was not a distant, abstract entity. It was a visible, tangible force that could, at any moment, reach out and seize them, dictating their fate with an iron fist. Let's delve deeper into some specific crimes and their particular treatment under medieval law, beyond the general categories we've discussed. Murder. While murder was a capital offense, the distinction between premeditated murder and manslaughter, unpremeditated killing, was not always as clearly defined or consistently applied as it is today. Often, the focus was on the act itself and its outcome. If a death occurred, someone was expected to be held accountable. The deodand was a curious legal concept related to accidental death. If a person was killed by an object, a cart, a falling tree, a bull, that object, if it was personal property, was forfeited to the crown or the lord, ostensibly to be sold, and the proceeds given to the church for prayers for the deceased soul. This reflected a belief that inanimate objects could be guilty of causing death and needed to be purged, or that the accident was a sign of divine displeasure. Theft. We've touched upon grand larceny versus petty larceny. The value threshold of 12 pence for grand larceny, which carried the death penalty, meant that stealing something as seemingly minor as a few chickens, a valuable tool, or a significant quantity of grain could lead to the gallows for a poor person. This harshness reflected the desperate economic realities of the time, where such thefts could mean starvation for the victim, and the need to protect property, especially the lord's. For petty larceny, theft below 12 pence, punishments included fines, flogging, the stocks, or branding. Repeat offenders, even for petty theft, could face escalating penalties, eventually leading to mutilation or even death. Rape. Medieval law treated rape differently than modern law, often focusing more on the violation of property rights. The woman was often seen as the property of her father or husband, or the breach of peace rather than the violation of the woman's bodily autonomy. Conviction was difficult, often requiring the victim to raise the hue and cry immediately and to present evidence of struggle. The penalty for rape could be severe, including castration or hanging, but convictions were rare, and the victim's reputation and social standing often played a significant role in the outcome. Arson, setting fire to property, especially homes or barns, was considered a heinous crime, particularly in a society where structures were often made of wood and fire could spread rapidly, destroying entire villages and livelihoods. Arson was a capital offense, often punished by burning the arsonist alive, reflecting the eye for an eye principle. Witchcraft and heresy. While more prominent in later periods, accusations of witchcraft and heresy were present throughout the Middle Ages, particularly as the Church consolidated its power and sought to suppress dissenting beliefs. Heresy, defined as holding beliefs contrary to official Church doctrine, was seen as a direct threat to the spiritual and social order. Those accused of heresy would be tried by ecclesiastical courts. If found guilty and unwilling to recant, they would be excommunicated and then handed over to the secular authorities for execution, usually by burning at the stake. Witchcraft, often intertwined with heresy, was seen as a pact with the devil and similarly dealt with extreme prejudice, though trials for witchcraft became more systematic and widespread in the early modern period. Sodomy, sexual acts deemed unnatural, particularly sodomy, were considered grave sins and crimes, often punishable by burning or castration. These were seen as affronts to God and nature, and the Church played a significant role in their prosecution. Vagrancy. In a society where most people were tied to the land, vagrancy, being without a fixed home or employment, was often treated as a crime. Vagrants were viewed with suspicion, as potential thieves or troublemakers, and could be whipped, branded, or even expelled from a community. This reflected the static, agricultural nature of medieval society and the fear of outsiders disrupting order. The social hierarchy profoundly influenced the application of law. A nobleman, for example, might be tried by his peers, other nobles, in a different court and might face different punishments than a peasant for the same crime. A noble might be fined, imprisoned in a tower, or even executed by beheading, a more honorable death, while a peasant would be hanged. The concept of status was deeply embedded in the legal framework. The role of the king's peace was central to the development of royal justice. In theory, all serious crimes were a breach of the king's peace, and therefore, the king had a right, and indeed a duty, to intervene. This concept allowed the monarchy to gradually expand its jurisdiction beyond its own direct feudal lands and into the territories of powerful lords, slowly unifying the legal system under the crown. This was a long, often violent struggle for power between the king, the church, and the feudal nobility, with ordinary people often caught in the middle. The medieval legal system, for all its brutality and apparent irrationality by modern standards, was a product of its time. It reflected a society grappling with fundamental questions of order, morality, and power in a pre-industrial, deeply religious, and largely illiterate world. It was a system built on custom, faith, and the sword, where the consequences of a single mistake, a moment of desperation, or even a false accusation could indeed mean that you would hang. The legacy of medieval law, however, is not entirely one of barbarism. The seeds of modern legal principles were sown during this period, particularly in England. The development of the jury system, the concept of royal justice leading to common law, and the gradual move away from superstitious ordeals towards more rational forms of proof were all crucial steps in the evolution of justice. While these developments were slow and often brutal in their application, they laid the groundwork for the more refined and, eventually, more humane legal systems that would emerge in later centuries. Yet as we look back, the overwhelming impression is one of immense peril for the individual. Life was cheap, and justice was often swift and final. The fear of the gallows, the stocks, or the branding iron was a constant companion for many. The lack of due process, the absence of basic rights for the accused, and the pervasive power of the ruling class meant that the ordinary person was often at the mercy of a system that was designed to protect the powerful and maintain order, rather than to ensure individual fairness. The soundscape of a medieval town would have been punctuated by the cries of the accused, the clang of the blacksmith's hammer on the stocks, the public pronouncements of sentences, and the solemn procession to the gallows. These were not just isolated events, they were integral parts of the social fabric, designed to educate, to warn, and to control. The law was not just in the books, it was etched into the very landscape and into the collective consciousness of the people. The study of medieval law is a stark reminder of how far our understanding of justice, human rights, and legal process has evolved. It forces us to confront a past where the stakes were unimaginably high, where a single misstep could indeed mean the difference between life and death, and where the concept of one mistake and you'd hang was not a dramatic exaggeration, but a terrifying reality for countless individuals. The shadows cast by the gallows of the Middle Ages still serve as a powerful testament to the fragility of life and the enduring human struggle for a more just and equitable world. We have explored the Manorial Courts, the Ecclesiastical Courts, and the powerful royal courts. We have witnessed the transition from ordeals to early jury systems and the brutal reality of medieval punishments. But the story of medieval law is not just about the formal legal structures. It is also about the daily impact of these laws on the lives of ordinary people. How did these laws shape their behavior, their relationships, and their understanding of right and wrong? How did they navigate a world where the power of the Lord, the Church, and the King could, at any moment, descend upon them? The threat of legal consequences permeated every aspect of medieval life. For a peasant, the most immediate legal concern was often their relationship with their lord. Failure to perform labor services, corvée, unauthorized hunting on the lord's land, poaching, or even moving away from the manor without permission were all offenses punishable in the manorial court. These were not abstract rules, they were the very fabric of their daily existence. Poaching in particular was severely punished, as game was a valuable resource for the nobility and a symbol of their exclusive rights. A peasant caught poaching a deer could face mutilation or even death, a stark contrast to the desperation that often drove such acts. The Church's influence, too, was ever present. The fear of excommunication, of being cut off from the sacraments and thus from the path to salvation, was a powerful deterrent against moral transgressions. The Church's teachings on sin, morality, and the afterlife shaped the worldview of every individual, and its courts stood ready to enforce these doctrines. Defamation, for instance, was a common charge in ecclesiastical courts. To spread false rumors about someone's character or morality could lead to public penance, reflecting a society deeply concerned with honor and reputation. Even seemingly minor offenses could have significant repercussions. Brawling in the village square, public drunkenness, or using abusive language could lead to fines, public shaming in the stocks, or even a night in the local lockup. These were not just legal infractions, they were breaches of communal harmony, and the community itself played a role in enforcing these norms. The very landscape was marked by the law. The gallows on the hill, the stocks in the market square, the pillory near the church, these were not hidden away. They were visible, public symbols of authority and the consequences of transgression. They served as constant, grim reminders of the boundaries of acceptable behavior. Children would grow up seeing these instruments of punishment, understanding from a young age the brutal realities of the law. The concept of outlawry was another terrifying aspect of medieval justice. If an accused person failed to appear in court after being summoned repeatedly, they could be declared an outlaw. This meant they were outside the protection of the law. Anyone could kill an outlaw with impunity, and their property would be forfeited to the crown. To be an outlaw was to be a living dead man, stripped of all rights and forced to live a precarious existence on the fringes of society, hunted and without recourse. This was a powerful incentive for people to face justice, however brutal it might be. The absence of a professional police force meant that the responsibility for maintaining order often fell to the community itself, or to the Lord's retainers. This could lead to arbitrary justice, where personal vendettas or local prejudices influenced who was accused and how they were treated. The accused often had no recourse against false accusations, and the process itself was designed to find guilt rather than to meticulously ascertain innocence. The medieval legal system was not static. It evolved throughout the thousand-year period. The early reliance on Germanic customs and blood feuds gradually gave way to more formalized royal justice. The Norman conquest of England in 1066 was a pivotal moment, as the new Norman kings sought to centralize power and establish a more uniform legal system, leading to the development of English common law. This was a system based on judicial precedent, where the decisions of royal judges in previous cases influenced future rulings, slowly building a body of law that applied across the realm. This was a significant departure from the fragmented customary laws of earlier times. The growth of towns and trade also led to the development of specific mercantile laws, often administered in borough courts, dealing with contracts, debts, and commercial disputes. These courts were often more pragmatic and focused on the needs of merchants, reflecting the growing economic complexity of the later Middle Ages. Despite these developments, the core principles of medieval justice remained harsh. The emphasis was on maintaining social order, punishing wrongdoing, and deterring others. The individual's rights, as we understand them today, were largely non-existent. The state, whether embodied by the king, the lord, or the church, held immense power over the lives and bodies of its subjects. The specter of capital punishment hung over a vast array of offenses, far more than in modern times. This was not just for murder, but for theft, arson, rape, and even repeated petty offenses. The value of human life, particularly for the lower classes, was often weighed against the value of property and the stability of the social order. The medieval period was a time of deep faith, and this faith profoundly influenced legal thought. The idea of divine judgment permeated the legal process, from the ordeals to the oaths sworn in court. Justice was often seen as a reflection of God's will, and the punishments inflicted were often viewed as divine retribution for sin. This religious framework provided a powerful moral justification for the often brutal realities of the law. The history of medieval law is a complex tapestry woven from custom, religion, feudal power, and the slow, often violent expansion of royal authority. It is a story of a society struggling to impose order in a chaotic world, where the stakes were incredibly high, and where a single mistake could indeed mean that you would hang. The echoes of these brutal realities still resonate, reminding us of the long and arduous journey humanity has taken in its quest for justice, fairness, and the protection of individual rights. The fear of the law was not just about the gallows. It was about the loss of reputation, the public shaming, the mutilation that would mark you for life, and the forfeiture of all your worldly goods, leaving your family destitute. For a peasant living on the edge of subsistence, the loss of a hand or an ear meant the loss of their ability to work, condemning them to a life of begging or starvation. The punishments were designed to be both physically painful and socially destructive, serving as a chilling deterrent to anyone contemplating a similar transgression. Consider the role of public opinion. In small, tightly knit communities, gossip and rumor could be incredibly powerful. If a person was widely suspected of a crime, even without concrete evidence, it could influence the presenting jury, the trial jury, and even the judge. There was no concept of a fair trial insulated from public sentiment. Indeed, the public nature of trials and punishments was intended to engage the community, to make them participants in the process of justice, and to reinforce social norms. The journey of the accused, from apprehension to trial to punishment, was often a public spectacle. The parading of the condemned through the streets, the crowds gathered at the gallows, the public display of severed body parts, these were not just acts of punishment but didactic performances, lessons in obedience, and the consequences of defiance. They were designed to instill a profound sense of fear and respect for authority. The legal system was also a source of revenue for the king, the lords, and the church. Fines, forfeitures of land and goods, and fees for legal processes all contributed to the coffers of those in power. This financial incentive could, at times, influence the administration of justice, making it less about abstract fairness and more about practical gain. The desire to maintain peace and order was often intertwined with the desire to maintain power and wealth. The concept of peace itself was central. The king's peace was not just the absence of conflict, it was the divinely ordained order that the king was responsible for upholding. Any serious crime was a breach of this sacred peace, an affront to the king's authority, and by extension, to God's will. This elevated the stakes of every criminal act, transforming it from a mere dispute between individuals into an offense against the very fabric of society and the divine order. The legal landscape also varied significantly across different regions and kingdoms within medieval Europe. While our focus has largely been on England, which developed a unique common law system, continental Europe often followed different traditions, heavily influenced by Roman law and the inquisitorial system. Inquisitorial systems, particularly those used by the Church for heresy, involved judges actively investigating cases, gathering evidence, and questioning suspects, often employing torture to extract confessions. This contrasted with the more adversarial, though still crude, system emerging in England, where two parties presented their cases to a jury. However, even with these differences, the underlying principles of harsh punishment, reliance on divine judgment, and the centrality of social order remained consistent across much of medieval Europe. The individual was largely subservient to the collective, to the church, and to the ruling power. The slow, often painful, evolution of legal thought and practice during the Middle Ages laid the foundation for the complex legal systems we have today. The very notion of a trial, the concept of a jury, and the gradual shift towards rational evidence were all born in this period, however imperfectly. Yet, it is crucial to remember the immense human cost of this evolution. For every step forward, countless individuals suffered under a system that was often arbitrary, brutal, and unforgiving. The medieval period was a time of immense change and upheaval, from the Crusades to the Black Death, from the rise of powerful monarchies to the flourishing of towns and universities. Through all this, the legal system adapted, sometimes slowly, sometimes brutally, to the evolving needs of society. But for the individual, the constant reality was the precariousness of life and the ever-present shadow of the law. The stories of those who fell afoul of medieval law are often lost to history, swallowed by the anonymity of the past. But the records, where they survive, offer glimpses into their lives, their struggles, and their ultimate fates. They remind us of a time when justice was a raw, visceral force, and when one mistake, however small or desperate, could indeed lead to the gallows. The legacy of this era is not just in the historical texts or the crumbling ruins of castles and cathedrals. It is in the very foundations of our modern legal systems, in the concepts of jury trials and due process that we often take for granted. By understanding the harsh realities of medieval law, we gain a deeper appreciation for the long and arduous journey towards justice and the profound value of the rights and protections that define our legal systems today. The fear, the superstition, the sheer power imbalance, these are the elements that define the medieval legal landscape, a landscape where survival often depended on not making a single misstep. The grim reality was that the accused often stood little chance. The lack of legal counsel meant they had to present their own defense, often against experienced officials of the court or the lord. The absence of a formal appeals process meant that once a verdict was rendered and a sentence passed, there was virtually no way to overturn it. Justice was swift, often public, and almost always final. The medieval legal system was not designed to be fair in the modern sense. It was designed to maintain order, uphold hierarchy, and extract vengeance or retribution. The concept of individual rights was nascent at best, and the idea of rehabilitation for criminals was almost entirely absent. Instead, the focus was on punishment, public shaming, and deterrence. This was a world where a single mistake, a moment of desperation, or even just being in the wrong place at the wrong time, could have utterly catastrophic consequences. The gallows were not just a symbol, they were a constant, terrifying reality for countless individuals who found themselves on the wrong side of medieval law.